Good afternoon. Welcome to the Heritage Foundation and our Lewis Lehrman Auditorium. We, of course, welcome those who join us on our heritage.org website on all of these occasions. For those in-house, we do appreciate the courtesy check that cell phones have been turned off as we prepare to begin. Of course, our internet viewers are always welcome to send questions or comments at any time, simply emailing speaker@heritage.org. And we will post the program on the Heritage homepage following today's presentations for all of you to have for future reference. Hosting our discussion is John Malcolm. Mr. Malcolm is the Ed Culbertson and Shirley Lindbergh Culbertson Senior Legal Fellow, as well as Director of our Edwin Meese III Center for Legal and Judicial Studies. Prior to joining us at Heritage, he held a variety of positions, including serving as a Deputy Assistant Attorney General in the Criminal Division at the U.S. Justice Department, and Executive Vice President in charge of anti-piracy operations at the Motion Picture Association of America, as well as the General Counsel at the U.S. Commission on International Religious Freedom. Please join me in welcoming my colleague, John Malcolm. John?
Thank you. Well, thank you all for coming out here today. So, as we all know, for many years, President Obama, and actually President Bush before him, tried to get Congress to pass immigration reform, and various iterations of the DREAM Act were explicitly considered by Congress and rejected by Congress. Then, in a bit of presidential prestidigitation, President Obama, under the guise, or some would say ruse, of prosecutorial discretion, announced two programs: the Deferred Action for Childhood Arrival, or DACA program, and more recently, the Deferred Action for Parental Accountability, or DAPA program. The upshot of these programs is that the Department of Homeland Security will take no action against millions of immigrants who are in this country illegally, and in fact, many of them are going to get work permits and other benefits. Now, Prince Clemens von Metternich, a very, very famous German-Austrian statesman, once said, "When France sneezes, Europe catches a cold." And as is often the case in this country, when the federal government sneezes, it is the states that catch a cold. And it is certainly true that the states will bear the brunt of this policy of non-enforcement. The state of Texas, joined by 25 other states, brought an action in federal court in the Southern District of Texas challenging this expansive executive action. And on February the 16th, Judge Andrew Hanen issued a 123-page opinion granting the plaintiffs a preliminary injunction which has, for the time being anyway, put the administration's plans on hold. We are very fortunate to have with us here today the Attorneys General from the state of Texas and Nebraska to discuss this very important case. We will first hear from Ken Paxson. Ken has a BA degree and an MBA, and I believe was student body president, from Baylor University, and a JD degree from the University of Virginia. General Paxson began his legal career at the firm of Strasburger and Price LLP, and then served for a number of years as in-house counsel at the J.C. Penney Company. In 2002, he left to start his own firm and to run for the Texas House, for a seat in the Texas House of Representatives. After serving in the House for 10 years, General Paxson was then elected to the Texas State Senate. While in the legislature, he championed Texas's voter ID law and was a strong voice for religious liberty and free markets. In January, he was sworn in as Texas's Attorney General, although I believe that there is some dispute as to whether you are actually the 50th or 51st.
We're doing our research.
Okay. Following a presentation from General Paxson, we will hear from Doug Peterson. Doug is a graduate of the University of Nebraska and of Pepperdine Law School. General Peterson served for 2 years as a state prosecutor in the District Attorney's Office of Lincoln County, and another 2 years as an assistant Nebraska Attorney General before entering private practice. In January, he was sworn in as Nebraska's 32nd Attorney General. Please take a moment in welcoming both Attorneys General here today.
Well, it's great to be here today. I think it is my first trip to this building, and to speak to you, I appreciate the opportunity. I also appreciate this opportunity in the legal world. And I'd like to begin by extending my appreciation to Senator DeMint and everyone else at the Heritage Foundation for helping organize this event and for being a leading voice in the conservative movement across the country. And many of you may know that in Texas, we have an organization that took its inspiration from Heritage, Texas Public Policy Foundation, and they played a huge role in making Texas the success story it's become. And I certainly worked with them for the last 12 years, and they've made a major difference in my legislative career. So thank you all for working with them as well. So the movement you're actively leading extends far beyond the Beltway, improving the lives of people not just in Texas, not just in Washington, but across the country. Thomas Jefferson, who was the founder of the university I went to for law school, once described the ideal government as so divided and balanced among general bodies of magistracy as that no one could transcend their legal limits without being effectually checked and restrained by others. Or as James Madison put it, the accumulation of all powers, legislative, executive, and judiciary, in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny. The good news is separation of powers and checks and balances remains the law of the land. The bad news is there are increasingly fewer people who seem to believe in that. That's disconcerting during a time when the President of the United States is attempting to end-run Congress to impose and implement his own immigration laws. That's not all what the country is about. Our country was founded on separation of powers, 3 branches of government, each performing their duties as best they can, working in tandem to make our country better for all of us. No one branch was intended to dominate the others. And I understand that can be very frustrating as a member of the legislature. I know how that is. But sometimes, let me give you a quote. Sometimes when I talk to immigration advocates, they wish you could just bypass Congress and change the law. But that's not how a democracy works. Oddly enough, that's not my words. I took that from President Obama, who said that in May of 2011. Also, a quote, administratively, we can't ignore the law. The fact of the matter is there are laws on the books that have to be enforced. You all know who said that. President Obama said that also in 2011. I can make light of how he's made a complete 180-degree shift in his thinking on this, but it's actually very troubling. Because nothing changed in the law between the time he was correctly noting the limits of his power and the time more recently when he decided he could do whatever he wanted. Other than the makeup of Congress, perhaps, but that can't be a factor when we define what a president can and cannot do. You can begin to see what the president is really up against as he tries to sell the courts and the American people on the idea that he can arbitrarily rewrite the laws whenever he likes. That's a big reason the lawsuit Texas is leading now includes more than half the states in the union, which is fairly remarkable and maybe unprecedented. They realize his amnesty program is awful public policy, but even more than that, they rightfully reject the idea of the executive branch hijacking the legislative process. Now, in Texas, we are facing major repercussions if this policy comes to fruition. You may remember that last summer we had a massive influx of illegal immigrants crossing the border in Texas, many of them children seeking to take advantage of President Obama's previous change in the law, which occurred in 2012. As we look down the barrel of this new, wide-ranging amnesty program, we have to keep in mind the massive effects this will have on our states moving forward. As President Obama continues imposing new laws to attract and retain illegal immigrants, states will have to pay more for education, health care, public safety, and the list goes on and on. In fact, Texas itself has had to beef up our border security since last June, spending more than $100 million of our taxpayers' dollars to increase law enforcement presence along the border since that time. Governor Perry even deployed the National Guard to help the overwhelmed Border Patrol, who were too busy dealing with unaccompanied minors to dedicate attention to keeping others out. Now we're looking at the prospect of a repeat of all of that, or even worse, should President Obama's actions be allowed to stand. Our new governor, Governor Abbott, who was the former Attorney General of Texas, it's worth reminding everyone, launched our lawsuit back when he was Attorney General in December, is solidifying plans to continue defending our border for as long as it takes. But Texas is not alone, and I'm thankful to have Doug here today. Every state would bear some of the weight of this decision. Again, a decision made by one man with no input from the states and no input from Congress. The question before us is whether any president should have the authority to circumvent Congress whenever a legislative battle proves too challenging. Texas and 25 other states have come together to say with one voice that this is fundamentally wrong and entirely unacceptable. Last week, a federal judge agreed with us, and I know you spoke of this, and stopped this program in its tracks a mere day before paperwork would be processed, and people who a day earlier would have been required to be deported would be invited to stay indefinitely. I'd like to read a couple of excerpts from the ruling, if I may. Usually these things are a little dry, but these ones are pretty good, and this is from the judge. The DAPA program clearly represents a substantive change in immigration policy. If anything, it contradicts the Immigration and Nationality Act. It is, in effect, a new law. That's from our judge. He also said the states assert that the government has abandoned its duty to enforce the law, and this assertion cannot be disputed. One more quote. This court finds that, directly interested or not, the public interest factor that weighs the heaviest is ensuring the actions of the executive branch comply with this country's law and its constitution. Now think about that for a second. A judge has had to actually say that the executive branch should comply with the Constitution. He also went on at length about how this program, once enacted, would be next to impossible to reverse, and I believe that. That actually makes the administration motion earlier this week asking for a stay so they could begin implementing this program not only disingenuous, but also devious. They're well aware that the second they begin running the paperwork, it's effectively game over, and the states will be at the mercy of the administration. Of course, that seems to be the way that President Obama prefers it. It is worth noting, by the way, that President Obama's action effectively allows millions of illegal aliens to cut to the front of the line in front of people who have been patiently waiting their turn to come to America the right way. There's a long way to go between here and there. However, we are firm believers in our arguments and the President's arguments, depending on when he makes them. Any of you who have spent much time in Washington, I imagine most of you here have, understand how the uncertainty that is our federal system. You know what panel, you never know what panel you'll be assigned. You never know what group of judges you're going to end up with. However, we're confident because we're on the right side of this argument, and we'll make the case as far as we have to. We're going to make the case because we're believers in the rule of law, and we understand the importance of preserving it. The rule of law, in fact, is what has always separated America from the rest of the world. Our founding fathers had just witnessed what happens when a monarch with unchecked powers asserted his will on his subjects, and they crafted a system to protect that from happening again. At the heart of it was the rule of law. The rule of law means not everybody gets what they want. The rule of law means that sometimes you have to live with the outcomes you may not like. Regardless, though, you follow the law, and for nearly 2.5 centuries, that's helped maintain our nation's status as a bastion of freedom and liberty for all. Once you undercut the rule of law, you dramatically weaken the foundation of the greatest democracy the world has ever seen. Even if the president thinks he's doing it for good reasons, we profoundly disagree with the president in this case. He runs the risk of undermining the beauty and genius of our system. The irony, of course, is that many of the immigrants coming here are coming here because they're fleeing the kinds of places where the rule of law doesn't exist or is ignored by the people in power. In any system of government, the rule of law is what stands between freedom and tyranny, and we can't afford to waver in that defense. The president's actions run counter to the principles established by our founding fathers and would cause significant, potentially irrevocable damage to the system of checks and balances that are the foundation of our entire system of government. In Texas, we'll continue to fight for the rule of law and the blessings of liberty that it provides. Once again, thank you all for being here today, and I want to thank Doug Peterson from Nebraska, one of my new colleagues, for joining me here as well. So thank you all. Look forward to taking your questions.
Well, thank you. I have to tell you, as was mentioned in the opening, I was in private practice for 25 years, happy and content, and then felt led to do this challenge. I'd never been involved in politics before, and my wife and I did a lot of soul searching and praying and got into this race. Well, I had no idea of how boring my private practice was until I got into the Attorney General's office. I stepped in there with a lot of bright lawyers to work with, sitting down. We were looking at a couple of these lawsuits. Both Ken and I, when we took office in January, our predecessors had already begun this lawsuit And also I had found that we had sued the state of Colorado on a marijuana issue. We had the Keystone Pipeline decision that was coming down. So it's really been, 6, 7 weeks, but been a very exciting time in this office. I've enjoyed getting to know Ken and his wife Angela, and I think both of us are excited, but in some ways everyone said it was a fire hose, and it definitely is in some of the issues that we're dealing. A lot of that has to do, though, because we do have a very aggressive federal government. In Nebraska, one of the big issues that we're addressing is the EPA's drafting of regulations under the Clean Water Act and the Clean Air Act. And for me, I do believe as a state you have stewardship responsibilities for your environment. But what really irritates me is when a federal agency uses philosophical motivations to cause states to have to respond, not based upon good science, but rather a philosophical opposition to coal and expansion of water rights. But I know the topic here today is with regards to the immigration lawsuit. And I shouldn't say immigration lawsuit, because I think, frankly, when we as attorney generals have talked about this case, it's not so much about the topic of immigration, but that's certainly the impact that it has. But it's really this extension of executive power, federal power, that has a significant impact. In Nebraska, we have a fairly significant Hispanic community. And in some ways, in a lot of these communities, it's really transpired since 1990 because a lot of that's due to the meatpacking plants that we have in Nebraska. In fact, one of the things that, for me personally, it's kind of exciting, my youngest son just took on his first teaching job of American history in a community called Lexington, Nebraska. Lexington, Nebraska is a classic community in Nebraska. It has 11,000 residents. 65% of Lexington is Hispanic, and that's due to the fact that there's a Tyson chicken plant facility there. And it has been, for my son, who's both a football coach and a history teacher, it's been a great experience for him in Lexington. And Lexington is a great example of how over the years this community has embraced and worked well as new residents are coming in, particularly from Central America. But that doesn't mean that we should allow a federal government to run without any accountability on its laws. So we joined in this action because it would have an impact on Nebraska. Obviously, in Texas, it's a much more significant impact, but it does have an impact on Nebraska because the community of both Lexington, Schuyler, Grand Island, Sioux City, these are 4 mid-sized towns in Nebraska with significant communities of Hispanic citizens, both who have been here for several years and have proper citizenship, and others who have come because of jobs but do not have that status. So the impact of this action by the president is significant. One of the things that is troublesome in the judge's opinion, Judge Hanen, there were 2 issues raised. It was brought under 2 claims. One was Article 2. The execution of powers responsibility of the president, and the second one was challenging compliance with the APA. And frankly, the judge went with the second argument primarily in the opinion, saying that the notice provisions of the APA Act were not properly complied with. I've seen that some professors, you're not a professor, are you? Because I'm about to criticize professors.
Go ahead. Have at it.
You've been to the real world, haven't you? I've seen some professors have argued that the ruling under the APA Act is not significant, that it could be corrected, or it's not a very strong opinion in that regard. And frankly, I think when you make a decision like this and you run it, though it wasn't an actual executive order, it was a policy development by the agency. When you do something like that, and what it does in impacting 4 to 5 million illegal aliens being able to be given a pass while in the United States, that is a significant impact, and it can't be ignored. I don't think this decision by Judge Hanen can be downplayed by simply saying, oh, it's only a process matter and it'll be corrected. The fact of the matter is the impact was intentional. It was clear in November that President Obama had said that if I can't get action in the Senate and in Congress, that I'll go about it another way. So clearly the intent was to have an impact of 4 to 5 million people be given new status in the United States and having a significant impact on states like Texas and Nebraska. And you can't abuse the power. You can't use the line prosecutorial discretion and have that type of impact. As Ken said, the rule of law is important, and that's the principle that we're fighting for, is to say that when you serve in the executive branch, you can't ignore the rule of law. And so we were pleased with the judge's opinion and hopeful on appeal. I do think, as Nebraskans, we very much have a common sense approach that our leaders, both at the state level and the federal level, need to show fidelity to the U.S. Constitution, and we feel in this particular case that was not done, and so we're hopeful on appeal. But other than that, I'll take any questions that you might have. I am also willing to talk about Keystone and Colorado marijuana because I have strong opinions on that. But thank you.
So in a moment, we'll take your questions. I would ask that you raise your hand so we can bring you a microphone. And then my three conditions are: one, please state your name and any affiliation you might have. Two, whatever it is you're going to say, keep it short. And three, please end it with a question mark.
And I have one that the very difficult questions will go to the very learned man from Nebraska.
And while we're waiting for people to sort of formulate their questions, so I'll take the moderator's privilege and ask the first one, which is, so I'm a former prosecutor, as are you, General Peterson. And so the traditional notion of prosecutorial discretion is that the law applies to everybody, but that a prosecutor, based on extenuating circumstances on a case-by-case basis, can decide, even though you're a clear lawbreaker, we're not going to have the law applied to you. Now, I've never heard of an instance of prosecutorial discretion in which the executive branch announces to the world that half of the lawbreakers in a particular category will have nothing to fear during this administration, and that the laws won't apply to any of them unless, in an exceptional circumstance, a prosecutor decides to bring a removal action. The judge, in his opinion, pointed out that nobody who has met the DACA qualifications has, fallen into this exceptional circumstance. What is the government's explanation for how this is a proper exercise of prosecutorial discretion?
I don't think they really had one. I mean, that's part of the reason that we got the ruling we did. The idea that you can say, our laws are pretty clear on this, that certain people who are not supposed to be here have to be removed. The president's memorandum, whatever you want to call it, executive action, isn't just not enforcing, but it literally is taking the opposite position, and it's creating a worker authorization program. There is no prosecutorial discretion. That's certainly what the government argued in the case, but there is no discretion. There's no discretion giving to the people making the decision. It's if they meet the criteria, which is they've come into the United States by a certain time, they're a certain age, or they're parents of citizens, then they satisfy. There is no actual prosecutorial discretion. The judge pretty much dismissed it as not a very reasonable argument. I don't know if you want to add anything to that, but it was ridiculous.
Yeah, when I read that phrase, I thought to myself, and John, you're right on the money, that phrase is used on a case-by-case basis because every case as a prosecutor, you have to evaluate a lot of circumstances as they apply to the law, and you have to use a degree of discretion, but you would never be so bold or arrogant as to say, I'm going to use this discretion across the board for everyone who may fall under this category, and I don't know who that may affect, but I'm just going to use it broadly. It's definitely always perceived in a context of a single case-by-case analysis. I looked at the phrase, and I frankly, what I said is, how stupid do they think we are? Do they think they can just say words and we'll just nod our heads and say, okay, fine? Can they tell us our intent is good? I went on their webpage and just looked at how they describe things. And I think they assume, maybe a little bit like the Affordable Care Act, that we're not very bright, that we won't really think in any depth or detail about these matters until the impact occurs. And as Ken said, once the impact occurs, it's very hard to put that back in the tube. So I thought using that as justification, they must think we are really stupid not to challenge that type of excuse.
You also made reference, General Peterson, to the APA, that's the Administrative Procedures Act, and the judge came to the conclusion that this was in essence a substantive change that would require notice and comment period to comply with the APA. The administration took the position, I gather still takes the position, that because this was prosecutorial discretion, the APA did not apply. Have you heard anything about the government making noise about saying, well, okay, we're still going to appeal this, but in the meantime, we'll put out for notice and comment and try to move along, or?
I have not heard that they're going to try to correct it that way. All I've heard is that they're immediately going to appeal.
Yeah, and that what we know right now is that they've actually asked for an emergency action by the district court in the Southern District of Texas, Brownsville Division, and that they basically said by the end of the day, if we don't have a stay, they've asked him to stay his own decision, which we'd be surprised if he did, that they're going to go to the Fifth Circuit. So this idea that they're going to now put out, I have not heard anything about that, and I don't expect them to actually do that, but who knows?
Okay. Are there any questions out here? Yeah, let's start right there.
Hello,
Yeah, it's on.
my name is Greg Robinson. I'm with the Speaker's Counsel's Office. I guess I was just wondering, building off of their stay and what they're requesting, do you have any idea about what the path is going forward? That is, if they do appeal to the circuit, how long that's going to take? Is the more substantive part of the case going to get stayed while they appeal the injunction? Do you have any idea?
Sure. No, we can't say exactly what the time is. We expect this emergency action to, I would expect it to occur fairly quickly within a day or two. Depending on how that goes, they may come back on the actual preliminary injunction and appeal that on a longer term basis. That I would expect maybe a couple weeks. The actual case itself, obviously, we haven't tried that case. We haven't actually tried our other issues, which was the constitutional amendment and the substantive violation of the Administrative Procedure Act. That could take, who knows, a year or so. So we might get a feel for this just on the preliminary injunction issue, because obviously to rule in our favor, the judge had to find that we would likely prevail on the merits. And so obviously, that's a pretty good ruling for us. So we're hopeful. You never know with the Fifth Circuit. We will draw a 3-judge panel, and we don't control who's on that panel, and we'll just, we're sort of up in the air on who that's going to be, and that could change depending on each part of the process. So we could end up with a favorable panel on one and not so much on the other.
There was another hand. I thought I saw a hand here. Let's go to there, and then we'll go to you, Joel.
I'm Daniel Hinkie with Senator Roberts' office. I had a question regarding the standing of the case. I know Hanen ruled against the executive orders, but did he also rule that states had the standing to bring the case? Because oftentimes judges will rule one way, but then say, by the way, the states don't have standing to bring it.
Yeah, standing, he said we did have standing based on, we made the argument that we, obviously have to have an injury when you're asking preliminary injunction injury, that the government is the proximate cause of that injury and that this is the only way to prevent the injury. We argue that we had significant costs and that all the states had significant costs, including education, health, law enforcement, and specifically driver's license. We stuck that in as an amendment to our original pleading. And the judge acknowledged that there were significant costs to Texas and likely to other states. And to us, it's millions and millions of dollars. And obviously, this was a process where normally, if we're going to impose those costs on states, normally there's a legislative process where there's public input, there's a debate, there's transparency, and you get some ability to have an impact on. This was just boom, it's done. Here's your new, potentially hundreds of millions and nationally billions of dollars of new costs for the states that they had absolutely no input in. So that was part of our saying. Then there was another argument made on abdication, and basically that argument that the judge went through, the federal government has pushed hard for total preemption on immigration issues. And so they pushed the states out in the Arizona case and others. And so the states have literally have had no impact on immigration decisions. And his argument was that if the federal government is going to do that, and then not do anything in the immigration area and actually do the opposite of what they're required by law, then that results because of these costs, results in a serious injury to the states, and they have, under this abdication theory, have standing to be in the case.
Thank you.
Yeah, let's go here and then back there.
My name is Joel Mandelman. I'm an attorney here in Washington. When this gets to the Fifth Circuit, do you plan to press harder on the issues of either the president seizing power he doesn't have in violation of Article 2 or simply usurping Congress's exclusive legislative authority under Article 1 rather than trying to deal with the APA issue, which personally I think is
the
sort of
APA
bizarre?
Well, the APA issue is a procedural issue, and that's the one that the judge chose to rely on. The merits of the case, when we actually have the opportunity to argue the merits of the case, we will be arguing both of those issues. The substantive requirement of violation of the APA, which is actually where you get your cause of action to make the argument that the president is violating federal law, and then the also serious claim that we have, which is the take care clause of the Constitution, where he's required to execute the laws of the United States. So yes, those will be the substance of our argument when we get to go back and argue the merits of the case. So he basically decided not to pursue those, that he had enough on the APA notice and comment and on a procedural issue, and so he said we showed enough harm, and as I told you earlier, the injury to make his decision on the preliminary injunction on that alone.
Well, if I can just follow up on one thing. What happened, do you know, to the 90,000 illegal aliens that showed up here last summer? Are they still in camps in Texas and other states? Have they been deported? Or
I couldn't quantify numbers and where they are. I can tell you that was another classic example of federal authority ignoring state rights, or even showing, is there a constitutional provision for state courtesy? Because when that occurred in Nebraska, we were told that there could be several thousand coming to Nebraska, and the governor tried to be insistent, asking the federal authority, give us numbers, give us details of the children, health issues, anything, and the federal government did not. And those were basically brought into several, children were brought into several communities with very little information provided by the federal government at all. There was no coordination, so it was pretty frustrating, I think, just another snapshot of the lack of respect that the federal government has shown to the states when it makes these types of decisions. But I couldn't quantify for you where those numbers ended up.
I will say in Texas, we have spent, since that time, significant resources, I think over $100 million, beefing up our security. Now, we don't have the same, we can't do some of the same things that border security can do, but it's dramatically impacted the number of illegals coming across our border. So we've had to put our own resources, and that's one of the frustrations we had on this abdication theory that the judge has. They've taken over this area, but then they're not actually doing anything with it. And so it's frustrating to the states. They argue so vociferously for preemption, and then they not only just don't do anything, but they actually go in the opposite direction and legislate the opposite of what the law says.
Arizona, I'm sorry, go ahead.
And that's why I do think the APA claim is significant, because if there's any opportunity for input, they need to comply with the guidelines of the APA, so that people actually do have an awareness of what's being proposed and to have some input. Because if not, if something like this were allowed to occur, a lot of this federal action could be under the radar. I know the constitutional stuff is juicier, but the APA stuff is significant.
I think it's worth just remembering that the state of Arizona actually offered to assist the federal government with respect to enforcing federal immigration law, and the Obama administration took Arizona all the way up to the Supreme Court and won to get Arizona to stop doing what it was doing to supplement federal resources to enforce immigration laws.
Well, and under DACA, they were also pushing for allowing illegals to get driver's licenses. Of course, that's a cost to us, which they offer no assistance on, and is another frustrating element of this process.
Get a hand back here.
The government argued basically that there's a lot of precedent for prosecutorial discretion, and that's the reason that they could go ahead with DAPA. And I think that it's pretty clear that they were encouraged by the fact that there wasn't any challenge to the DACA program. And it goes back, of course, earlier than that. It goes back to the wet foot, dry foot policy that was proclaimed by President Clinton that allowed in large numbers of Cubans and waived any immigration enforcement against those people coming into the country illegally. If they are able to get by this particular lawsuit, do you see anything that would restrict in any way an expansion of this, in effect, to all of the people who are in the country illegally or continue to come into the country illegally?
I would say you're accurate. If they, and it's not just immigration. I mean, this is an immigration case, but this is a constitutional issue. I'm not sure that the president can't legislate anything after that. That the separation of powers idea is somewhat defunct, and Congress can debate all they want, and if it doesn't get done on any issue, the president just legislates from where he's at. I think it's an attempt by the current president to see if he'll be challenged if he goes beyond his constitutional duty. So it's fundamentally, whether you agree with this policy or not, it's bigger than that. We could have a next president that, if you agree with this one, the next president may do things you don't agree with. It's a process of checks and balances that I referred to at the beginning that Jefferson and Madison talked about, that fundamentally at the heart of this case. And that's really why we got involved in this. It's that constitutional issue, not just the immigration issue.
There was another hand back right behind, and then we'll come down here.
Hi, I'm Chris Opram with Bloomberg BNA. Question for Mr. Paxson. You said it was important to get the injunction ahead of time before the administration started processing applications. I was wondering if you could go into a little more detail about that and also explain what might be the threat if the injunction gets lifted at the appellate level.
That's a great question, and the problem we have is the cost to our states is significant. Once this goes into effect, again, we haven't had any hearings on this. We haven't had notice comment. Our legislature's in session, and most legislatures are in session now. They weren't planning on having to spend this money. And so we're talking about hundreds of millions of dollars of costs as it relates to the issues that I talked about: health, education, law enforcement, and issuing simple things like driver's license is going to cost millions of dollars. And so if it goes into effect without any of that, without any ability for us to comment on it or to say we don't want it, those costs are imposed. And the question is, how do we go back? How do we unissue a license? We'll never get the money back that we've spent on this that we would have otherwise spent on other things. And Nebraska will be in the same boat, and Tennessee, and all of these other states. So it's difficult to step back. And the government, in my opinion, has a very difficult time of showing any harm. This is the status quo. We're at where we're at now. It's the same position we're at. I don't see how they are harmed by actually letting us try this case on the merits and holding off on implementing before we've actually had the case tried. So we can show, I think, great harm. I don't see what harm they have at all. And I don't know, Doug, you may have.
No, I agree that the first sign-up date was going to be February 18th. And it's a lot like the marriage laws. If you go ahead and don't stay, and that's what I could be getting an email here any minute whether or not the federal judge in Nebraska is going to uphold our constitutional amendment that marriage is between a man and a woman. But one of the things we asked is to stay in that particular case. These are the type of things that preliminary injunctions or temporary injunctions are important because it will be very difficult to avoid the harm unless the court intervenes quickly. And that's why I think in this particular case, particularly Texas, but also Nebraska, it affects big change if this is not fully processed through our appeal system before they try to implement.
We had a question down here.
Hello, I'm Jim Robb from Numbers USA. Here's a non-lawyer's question.
I didn't think that was possible here.
So there's an injunction. They're appealing it to at the district court, I guess, and we're trying to get an emergency stay. Saying that fails, it's going up to the 5th District.
Fifth Circuit.
5th Circuit, excuse me. And then it's a three-judge panel. If they fail there, do they have recourse to keep appealing?
Sure. They can ask for the Fifth Circuit en banc with all of them there, or they can appeal it straight to Justice Scalia's over the Fifth Circuit and appeal it to the Supreme Court. So, yeah, they definitely have options.
Justice Scalia would take a first crack at it, but if you wanted,
Yeah.
he could refer to the entire court. That's the way that would proceed. We had a question back there.
Thank you. Todd Gilman with the Dallas Morning News. General Paxson, good to see you.
Hey, good to see you too, Todd.
The timetable that you laid out for
You've
how
come a long way to ask me a question.
About a half mile. Yeah. The timetable that you laid out for the full course of the case for the case to play out almost brings us to the end of the Obama administration, doesn't it? Is there an
Do you see
element?
the tear?
Well, I mean, is that part of your legal strategy, is to stretch this out long enough so that you hope to have a president who doesn't quite see it the same way?
Not particularly. I mean, the legal strategies, we really did care about the constitutional issues and the violation of federal law. So that was not I mean, it came when it came, right? I mean, he chose the timing. We didn't choose it at all. So we're just responding to his actions in the time frame that he's given us, and we don't control the court process timing either. So we made no strategic decision about timing. He did.
No, I mean going forward.
Oh.
It would be to your advantage to try to stretch this out as long as possible and possibly beyond the Obama administration.
I suppose, but that's not, the timing is not controlled by us in any way. So it's, whether it's to our advantage or not, was really determined by the Obama administration. We're fighting it because we believe this is a bad precedent, both constitutionally and just in violating our federal law. So the timing was purely their decision, and then it now comes down to the court's scheduling. So we'll pursue this as quickly as we can, but we're not in control of the schedule, and they're the ones now appealing. We didn't appeal. So they're actually, if anything, it's them stretching the time out, not us.
So if the stay were to hold, the next thing that would happen would be Judge Hanen would have a scheduling conference to talk about any pretrial motions and presumably set a date. for
Correct,
trial.
and he'd already asked for that, and we were about to get into that process. And of course, it took the Obama administration about a week to pursue this. So we thought they were actually we were expecting it sooner. So anyway, you've accurately portrayed we were headed down a week ago.
Okay. Are there other questions here? Yes, over here.
Hi, I'm Peggy Orchowski. I'm a congressional correspondent with a Hispanic outlook, and really sorry I'm late, and so I might be repeating a question here, but I can.
Yeah, we already answered that one.
I don't understand how. Well, I'm not sure what jurisdiction Obama has to prosecutorial discretion. Fine, give work permits. I don't understand that part. But what I really don't understand is how can he force a state to offer driver's licenses to illegal immigrants if you don't do that normally? That is clearly a state jurisdiction. So how can he force that?
Do you want to answer, Doug? I'm happy to take it.
Well, that, and I think the gentleman back there gets to the heart of the question. This action by the president is very significant. I don't think you could underplay it because it is such a, the separations of powers. As I get older and see things, I see more and more how the founding fathers had such wisdom in how they created this structure. And also, as I get older, I see more how we try to violate it in various ways. And I think both parties, Democrat and Republican Party, need to be very concerned about this because it's the biggest threat that, I shouldn't say the biggest threat, but I mean it is a significant threat to the separation of powers, not only among the federal branches, the three branches, and executive over the legislative, but also between the states and the federal government. And certainly that's why we think this battle is so significant. The driver's license issue is just one example, but it's much broader and deeper than that. And I think it's so significant that our legal system protect the constitutional framework that was designed with real wisdom and insight. I think if he were allowed to do this, it would really set such a dangerous precedent to federal control.
How can he? Why did the state
Well-
say, no, we don't do that?
Well, normally driver's licenses have been considered a state function almost exclusively. However, I may have the case cited wrong, but the judge mentioned Arizona. I think it's Arizona v. U.S. If I got the case wrong, but generally, the states challenged issuing driver's license to individuals under the DACA program, which was the 2012 program, and lost. And so, under that case, we're forced to incur the cost. And for Texas, the people who are getting their driver's license, I think our fee is $25, so the state incurs about $175 cost. Well, add that up over millions of people, and it ends up being a decent amount of money for the states to incur. Again, not something that we planned on having to spend. And so we have been forced, and that's getting back to his whole the judge's argument on abdication. You force the states through preemption to accept federal law, then you don't enforce it, and you create other laws that are antagonistic to actually enforcing, and then create costs that the states have no choice but to incur because you've told them they have to.
So DACA
Thus,
has
26 states are
driver's
filing a
licenses.
lawsuit.
DACA has driver's licenses. I didn't know.
That-
But as I recall, Judge Hanen said in essence that the government was arguing kind of out of both sides of its mouth. But it was saying before him that the states could decide about driver's licenses, but noticed
That
that,
they would-
the government had litigated against another state, I think it was Arizona, saying that they had to issue driver's
That's exactly
licenses.
right. So the federal government is exactly as you said, is arguing out of both sides of their mouth, and he basically caught them.
I was a little bit surprised, and I was wondering if you'd comment on this. So the judge spent a lot of time talking about the driver's license issue, and noted that your state would have to pay this fee for all of these driver's licenses, and it gave almost only a passing reference to education costs, healthcare costs, and unemployment benefits for which you would also be out of pocket. Is there some reason why that was so? Do you think?
I don't know. But he did mention he did note the cost of education as being over $700 million potentially in this case, and he did give a cost to healthcare costs. So he did note, while he did cover driver's licenses in a lot more detail, he did cover those issues that you're talking about.
Yeah.
Maybe not to the same extent, but he did give a dollar figure to him, and potentially we might have helped them with those dollar figures. So.
Other questions?
Wasn't health in schools, so that was a Supreme Court ruling in 1983, so that, that is not a state decision, unfortunately.
Well, that's correct, but the problem we have is he's not enforcing the law, and we are having to incur these costs outside of what how the law should be handled, which is to follow it.
Yeah, no, there are federal laws like that. Like, for instance, if someone shows up in an emergency room and they have a genuine emergency, hospital can't turn them away, that's a non-reimbursable expense, and the state will often bear the cost of that, too. So
John, we have another issue similar.
Yeah.
Not similar, but I mean, it's, again, this tension between the federal government and the state government. We have the Controlled Substance Act passed by Congress back in 1970, which we assumed all the states would comply with and design their drug laws around that. And now we have the Department of Justice saying to Colorado, go ahead, you can use it for recreational purposes, and then the ramifications that has on neighboring states. So this dance between the federal government and the state is being strained quite a bit right now because of the inconsistencies, and there's several of examples of it. And I think Ken and I and several other attorney generals feel that it's way too important to simply ignore or allow to happen, and that's what activates a lot of this legal activity.
There's a hand back here.
My name's John Shadigan. I'm a former member of Congress from Arizona. I want to clarify the
And
last...
a lawyer, right?
And a lawyer. With Steptoe and Johnson. They'd want me to say that.
I knew it was coming.
I want to clarify the point you just raised. With regard to education and healthcare expenses, I believe the argument goes that if they are here, you have to provide those anyway, except that isn't your argument that were the administration doing its job, they wouldn't be here.
That's
and
exactly...
they would have been deported, and they wouldn't be incurring those expenses. You wouldn't have to pay for them. We all understand that those services have to be provided to people who are here, but if they're only here, they're here because of their illegal conduct, and they could otherwise be deported, that results in the
Congressman,
imposition
can we
of
get
cost.
you reelected?
Here I go. Thank you very much.
Well, I'm waiting for another hand. What do you say to the argument that the Department of Homeland Security has made? Hey, Congress appropriates money, and we really only, we have 11, 12 million illegal immigrants in this country, and we can only deport so many. And therefore, really, is a matter of sort of public safety we're picking and choosing. And just get to their response.
It's
to that.
it's very, in my opinion, very attenuated because obviously, if you whatever your resources are, you can only do whatever you can. But to actually just blanket statement say, okay, here's the law. Well, now the law is the opposite of what Congress said. And by the way, we're going to add on to that, and we're going to allow these people to work here. That, I mean, the argument makes no sense to me.
Yeah. And there are a lot of resources being devoted to setting up these programs to hand out work permits and all that
Right.
could
What
be
they
used.
should be doing, if they don't have enough resources, they should be making the case to Congress, which they have not, that they need more money. But that's not, this is the court called it disingenuous, and I call it disingenuous and devious.
Are there any other questions that we have here? Yeah, back here. We'll have a repeat question.
Jack Martin's my name. I didn't identify myself the last time.
Are you a lawyer?
But no, I'm not. With regard to the last comment that was made, if the state patrol announced that they were only going to start enforcing the law against people that were driving over 80 miles an hour because they didn't have enough resources to enforce a 65-mile-an-hour limit, the new speed limit would be 80 miles an hour.
Right.
And it's the same thing with regard to immigration, I would suggest, and that is if you announce you're not going to try to remove people that fall into this category, that's in effect an invitation to all of the people that fall into that category to come into the country illegally.
Which is why this is so important, because if the Obama administration can do it on this issue, then, and it's okay, and we don't challenge it, then what's to say? I'm sure we'll be seeing this over and over from every president, and that's just not how our system was set up.
Yeah.
Is Nebraska planning to challenge on the same basis the administration's refusal to enforce the marijuana laws because of the adverse impact of what's happening in Colorado is having on?
You're taking General Peterson up on his invitation to
Yeah,
ask?
I mean, is there a plan?
Yeah, a
that?
lawsuit, we filed, it's because it's against the state of Nebraska, against the state of Colorado. We filed an original action with the U.S. Supreme Court. And Colorado has, I believe, March 27th, they have to respond to that, our request. And it has had a big impact on Nebraska. It's interesting, the analogy you use about the 80-mile-an-hour policy. And obviously, if you did that, then the federal government would turn around and yank all your Department of Transportation grant money. I mean, that's how they create the relationship, and that's how they get around the enumerations of powers. They say, well, no, we don't have power under the Constitution to do that, but we have money. And then you start dating that girl, and you know, it's hard to break the relationship off. So it's a real frustration here, though, with this Department of Justice deal. What we're seeing is some of the strongest marijuana ever come into our state. We're seeing young people impacted by it, and it's all because of our U.S. Department of Justice refusal to enforce it.
It's going to be tough following up that comment. Go ahead.
No, my follow is there a plan to sue the Obama administration over the marijuana issue?
No, we're trying to.
That's what I was-
Yeah, no, we're trying to argue it under the supremacy clause against Colorado, which we shouldn't have to be doing, frankly.
We have that down here. Sorry.
Hi, Mike Hethman, Immigration Reform Law Institute. My question is, I noticed the litigation didn't challenge the 2012, the original DACA program. And I certainly feel that if you get to the merits, which I think you will succeed, and it seems to me that the arguments that you're making would also apply to the original DACA and probably to the various smaller deferred action, categorical deferred action programs that we've seen pop up since the immigration reforms of 1996. And I just wanted to see if you had some insight on on why you structured your claims as you did.
So actually, before you answer, just to clarify, so the DAPA program made some changes to DACA, and that was enjoined by the judge,
Exactly.
but he
So
left alone the original DACA
It
program.
extended DACA to more people, and so we did get an injunction, and that was included in our lawsuit. As to why, original DACA wasn't challenged, I really think that's more the Attorney General's fault from Nebraska, who was in there before him.
Last time I joined you,
We weren't in office, so, we got the suit as we got it. So we're pleased with it. We think we're going to eventually, we hope to be successful. We think we've got a good shot. If the law matters, if the Constitution matters, we'll be successful on the claims that we brought. But as far as why they decided not to go after DACA,
Right.
we weren't in office.
Other questions? Yes, down here.
Caroline Castigliola.
Hold on, let's get to the microphone.
Caroline Castigliola from Senator Wicker's office. There was a question earlier about the standing issue, and as you mentioned, Judge Hanen found that there was standing in, for the reasons you articulated. How concerned are y'all that moving forward, standing could be the deciding factor in the case rather than the merits?
We feel very confident in our standing argument. We think the judge clearly got it right. There's no doubt that when you end up on the Fifth Circuit, you don't really know, as I said, which panel you're going to get and how they're going to look at this. But I'm sure that'll be brought up by the administration, and we'll take it on. We think we've got great arguments. We think the judge analyzed this in the correct way. And I think the way he put it was, if this case basically doesn't have standing, then who would?
Yeah, and I would say, I think other states evaluated that the same way. I think what occurred last summer in Texas was a good example of what Texas was put through as far as real harm. And so I think all the other states felt if there's any state who should be the lead in this, it would be Texas.
So we have a hand here and then one back there, so we'll go here and then back there.
Quick question, don't know if you know this. Do you have any idea how, not only how many people would get these benefits in your states, but what proportion are Latinos? I assume in Texas probably be the majority, but I understand that 30% of DACA recipients are actually Asian, not Latino. So this is not just a Latino issue. What about in your state? Do you have any idea?
I'm not remembering right off the top of my head the number. I know the total number, 4.5 to 5 million is the estimate. Obviously, Texas would have a significant number of those, but I don't remember the exact number that would end up in Texas. Not sure we guessed on that.
And Latino, most of them probably.
I too don't have the ability to give you exact detail. We have a Somalian community also that would be affected by this, but I don't have numbers.
Thank you.
So there's a report that just hit my inbox that apparently the administration is considering implementing this program in the states that are not covered by this particular lawsuit. So what would you make of that?
I think it's a bad idea.
Is there anything legally at the moment that would stop them from doing that?
Yeah, I mean, I'd have to go back and think about that one. It would be an interesting approach on their part, and I'd have to go back and kind of fit the language of the judge's preliminary injunction into my head. So I don't really have an answer for you right here. I'd have to think about, because mostly I've thought about this lawsuit more in terms of my state and the states that are part of our lawsuit. I haven't really thought much about what happens in these other states.
What would be next? To go to the 24 that didn't join your lawsuit?
Possibly. Well, and the fact of the matter is it impacts them all. I imagine with some of the attorney generals, there's politics involved, and it's difficult for them to do that. But ultimately, our oath of office is to the citizens we represent. And I don't think that D or an R on something like this should matter. I think it's a step-up moment for all states impacted by this.
Other questions? Well, Generals, I really appreciate your being here. I hope you'll come back often to Heritage, and please take a moment and join me in thanking you.